Okay, welcome everyone to the March version of the HR Best Practices webinar series. My name is Kevin Mosher. I'm an attorney partner up at the Thompson Co. Minnesota office, and I will be presenting for you this month like I do most months, though periodically we do have guest presenters, and this year in 2017 we'll have guest presenters as well. But this month, it's my pleasure to make this presentation on documents and retention, filing tips, rules, and rules. A couple things on the webinar series, and I suspect a lot of you on this call have been on these webinars before. Looks like we have a new format from GoToMeeting this month. Kind of looks a little slicker, at least on my end. The couple things to know. One, if you need your SHRM or HRCI credits, you'll be sent a certification after we verify your attendance on here, and that'll come to you in an email probably within a week of this webinar. If you have any questions, you're welcome to write them into the question box on the right, the little chat box, and that'll show me that at least I have questions, and I'll periodically try to take a moment to look at the questions to see if there's anything that I haven't addressed that people have questions on. We otherwise don't have much interaction here, but you're definitely welcome to write out any questions. So this month, this month a little bit different than the last couple months. Last couple months we've had a little bit, I don't know, I mean, I guess I would say probably a little bit more exciting topics on trumping HR, what HR practices might look like under a Trump administration, a little prognostication seminar, and then the new I-9, I-9 always riveting, near and dear to my heart, absolutely love the I-9. So we will cover a little bit of the I-9 on this webinar, but it's just going to be a very brief overview of that. We're otherwise going to run through a lot of documents and rules and just ideas on how to manage your documents. And clearly we are not going, many of you may have issues with certain documents and questions. I mean, there's no way for us to cover everything in 1 hour on documents. There are just so many different documents, and some of you, will focus on benefits, and some of you won't focus on benefits, and some of you will be more focused on hiring. So it's just, there's just so many documents out there that are within the HR realm. So we're going to cover at least some of them. We're going to talk about a flow as well of documents, and then some tips on discipline and documentation for that as well. But certainly if you have questions on other documents, you're welcome to reach out to me or ask those questions along the way as well during this presentation. I'm really excited because I actually have slides. This handouts. Oh my gosh. Okay. Hang on. There we go. Okay. Not sure it wasn't advancing on me. So what are we going to cover? Documentation 101 is that we need to talk at least, about an employee handbook. We need to talk about personnel files. We need to focus on hiring and disciplinary practices. And then I'll talk about some key documents under the FMLA, I-9, and then medical information as well. So I think we're going to get a pretty good overview here. But like I said, I mean, the world of documents and HR is ever vast and seemingly never ending. So certainly, if you have questions, reach out to me after the webinar, or type in the questions as we go. Okay, so starting with the personnel file, everybody loves a good personnel file. Now, here's the thing. Under federal rules, there is no definition of what a personnel file is. HR people tend to have best practices for what a personnel file is. I mean, there's no law that, federal law anyway, that says this is a personnel file and thou shalt always have thus and thus document in a personnel file. Now, a lot of states do. A lot of states will have access laws. So, I've got a few states, a slide on that later, but a lot of states will define what a personnel file is. And so we really need to know, I mean, I can sit up here and tell you what a personnel file is just generically and what a typical best practice is for employees, but the reality is that we need to know what each state does. Now, it's not like you have huge changes from state to state on what a personnel file is, and certainly states aren't, I don't know of any state that's going to tell you like you have to have this document and it has to go in a personnel file. That's not really how it works. Normally how it works is the state will say, that the employee has access to their personnel file, and then the state will define what that personnel file is. Now, if you don't have something in the personnel file, like you don't keep, some sort of disciplinary record. I mean, you have to keep an application. That's, if you do an application, and you should, if you do an application, a written application or an electronic application, you need to keep it for a set period of time under some state laws, I suspect, but under federal law as well. But it doesn't mean you have to do it. So if you do it, then a lot of these states will define what exactly is in that personnel file. And, so what typically best practices, what we commonly see, that sort of thing. So this is just generically going through, this is what's in a personnel file, right? So we've got an application for employment. I suspect, if you're an HR person out there and you don't put an application for employment in a personnel file, or at least electronically save it somehow, so it's tied to the employee, you're probably unique in that regard. I think that's, applications for employment are something that we definitely want to retain and keep in a personnel file. Wage and salary history, you may put an offer of employment letter in place of this. So your offer of employment to somebody saying that, hey, this is the job we're offering to you. If there are any changes in that job, any changes in that salary, you may create a form. And again, there is no guideline, there's no rule on what this form needs to look like, but a lot of employers will use a form that's basically a transactional a change form, a change of status form, a change of terms and conditions of employment form. You can call it whatever you want. You can put whatever information you want within reason on that form, but the form basically says, like, this is the change. So, what is the current job that the person has? It's clerk. What is the new job? It's head clerk 2. And, change of status, and then there'll be a little thing that says, what's the current salary? $10 an hour. What's the new salary? $12.50 an hour. And so you'll just have that, and then any of those change forms would definitely go into the personnel file. If the employee has any sort of authorizations to deduct or withhold from pay, you definitely want to have that in the personnel file. Honestly, that's just to protect you. So many states require contemporaneous written authorization from employees before you can deduct anything from their wages outside of FICA and other taxes, and so other, outside payroll taxes and in benefits. But anything outside of that, many states, I don't know what the breakdown exactly is, but many states, if not most, require that you obtain contemporaneous written authorization. And so you definitely want to have that just to protect you from government action for illegally taking out wages from somebody, or taking out deductions from somebody's wages. You want to have that on file. Fringe benefit information, not the medical information tied to the fringe benefits, but potentially the election forms, or potentially even information on the plan. That would be something that you might want to typically include in a personnel file. Leave records, attendance records, these are all kind of tied together. Again, not medical information. We're not looking at medical leave records related that have medical information, which we'll talk about later as well, but just general leave attendance records, we want to have that. That's all considered generally part of the personnel file. I already talked about the compensation, change of classification, change of compensation. We want to definitely have something in there. And again, you can create it on your own. It does not have to be fancy. It doesn't even have to be signed off on by the employee, but we definitely want to have some sort of document. Again, whether it's paper or electronic, we want to have some sort of form, some sort of information that documents that this change occurred. And really, a lot of these are defensive for you. If the Department of Labor comes and audits you, or if you get a lawsuit for like wage, like a wage claim, whether they're claiming that they're non-exempt and they weren't paid overtime, that sort of thing, or wages were illegally taken away from them through deductions, you definitely, I mean, this is to protect you. You want to have a paper trail. You want to have a history showing what you've done, when you've done it, why you've done it. And again, it doesn't have the, with changes in employment, the employee doesn't have to sign off on it. They do with deductions outside FICA taxes and benefits. They do have to authorize that in writing in most states, but for the most part, we just want to create a paper trail that helps us in any sort of potential audit by a government agency. What is not in the personnel file? And again, this kind of goes state to state, but I'm just going to give you some general pointers of what I don't think is typically in a personnel file, though I understand, I'm not here to make anybody nervous. I understand that companies throw a lot of stuff into personnel files. And so what I'm saying is, I'm not trying to, beat you up over that. But in my mind, these sorts of things on this list shouldn't be in a personnel file. They might be in some sort of other file that you have for an employee. Certainly medical information would be in a secured, protected medical file that would have restricted access and under lock and key and that sort of thing. But other things that don't necessarily have to go into a personnel file, again, some of these might be able to go into it. It's fine if that's how you organize things outside medical records, but they don't have to go in a lot of states. And so, just going down this list, employee references, again, don't have to go in the employee personnel file. In many states, employees don't have a right to see, what the references were that came in on them. So if it's in a personnel file and you go and you let the employee have access to it, because a lot of states allow, entitle employees to have access to their personnel files, you don't necessarily want references to be in there, because then the employee sees them and maybe they get all angry and then go and punch the person that gave them a bad reference. Although honestly, if they were a really bad reference, you probably wouldn't have hired them in the first place, but who knows. An investigation into criminal or civil violations, investigatory notes along those lines, harassment investigations. If we're doing an investigation of an employee, that does not have to go into a personnel file. And again, caveat, if the state that you're in requires that it goes into a personnel file, that may be. But most states that I'm familiar with don't require this information to go into a personnel file. It would go into a separate HR investigative file that, again, probably want to have it under lock and key. In fact, HR should just lock their door entirely, never open it, and then you wouldn't have to see anybody. Look at that. You'd get so much done. You wouldn't have to see people like coming in. Just lock your door. You'd live in a vault, and it'd be like the greatest HR existence ever. Culturally, maybe not so great, but from a getting work done perspective and keeping everything secure, look at that. It'd be like 4 stars. Education, medical records. The medical records are the key here, just like testing records that might have medical information on them. And people talk about PHI, but really for most, unless you're a medical facility, a hospital, that sort of thing, most employers don't really have to worry too much about PHI, but we do have to worry about medical records because of the FMLA and the ADA. So medical records absolutely have to be separated. Testing results might have medical information depending on the type of test. If it's an education record, that could be in the personnel file, but it doesn't necessarily have to be. Salary system, that's something that you would just have separate anyway. If you have a structured salary with classifications and then steps within that classification, for example, or minimums at certain levels, most employers of a certain size have that sort of classification structure. And so if you've got that, then that would be separate. We just want to make sure that we retain it in case we get audited. But again, it's not something you would probably throw into a personnel file. And that one might make the most sense out of all of them on this list. Comments or data of a personal nature about an employee. If you're getting first of all, we don't really want to keep that stuff anyway, unless it's relevant to the job or an investigation. So, if a supervisor, especially if it's a supervisor or a manager or even a coworker is sending some sort of email about, the employee's personal life, it's just not the sort of thing that should go into a personnel file. It's the sort of thing that hopefully just kind of gets deleted or goes away. If it's job related, that's a totally different thing. But if it's just a personal thing, we really don't want that in the personnel file. And in fact, it could be a problem if it's in the personnel file, because if it's in there, and depending on what that personal nature data or comment is, it could be indicative of a bias, animus toward some sort of protected class. You just never know. Somebody complaining about another's religious practices, or that they don't celebrate birthdays, and the person's Jehovah's Witness. I mean, that could be seen as bias, as animus. And if you go to discipline or fire the person later on, or if they feel like they're working in a hostile work environment, that could be an adverse employment action that potentially they could at least argue, and they might have some basis for it, or at least could make the argument a little bit more cognizantly that they were illegally terminated because of their protected class, because in the example I gave of their religion. And so we definitely don't want this type of garbage, personal nature comment type stuff in personnel files, just to protect you. So and look at that, you're saving on paper, or saving onto an electronic system. Comments or data from their supervisor, again, non-work related. So that's implied in that bullet point. We definitely don't want work-related comments or non-work related comments from their supervisor. Again, it just opens you up to potential liability and second guessing that the supervisor has some sort of illegal animus or bias, or not illegal animus or bias, but if acted upon, could be an unlawful employment act of discrimination. Privileged information. There are certain, now you might have certain things like banking details, and with forms that you're filling out, but there could also be some privileged information of a personal nature that just shouldn't go into a personnel file. And the way I think of it is, and I understand you might have all your personnel files under lock and key, and nobody gets access to it until they pay homage to the HR person and fill out forms and give some genetic testing stuff, all that sort of great stuff. You might have a really great system in place. Not all employers do, and so a lot of employers will allow supervisors and managers access to personnel files, or at least supervisors and managers will give themselves access to personnel files, and they'll go and they'll look through stuff. And so what we don't want is, we don't want things that could influence those supervisors and managers into taking adverse action against employees because of some sort of protected class. So we don't want information in there that could be acted upon that might be confidential. It's why we don't want medical information in there, because we don't want supervisors or managers taking actions based on the perception or reality of a disability. So we just don't want that. It's to protect us from eventual lawsuits from employees who get disciplined and fired, because that happens. Written statements about job performance that disclose a coworker's name or identity. So ideally, job descriptions are going to be in the personnel file. That makes all the sense in the world. But sometimes you may not want to include, or you definitely don't have to include, in a lot of states, the other evaluation or comments that come from coworkers. Supervisors, totally different thing. But a coworker, if a coworker's opinion is solicited on somebody's performance, it's not the sort of thing that you definitely have to have in a personnel file. Oh, so under this new format, I thought that the drawing tool was questions, but again, it's not. Okay, so I got a few questions. Somebody's asking for a link to the materials, and just so you know, those materials were all sent out about an hour or an hour and a half ago to everybody, so they should be in your inbox if you haven't, if you didn't see that. Okay, let's go through some basics. If I can get the screen. Okay. Okay, so why is it, just starting out with documentation, and I know, the phrase, the cool HR phrase is, document, 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 and there's some truth to that, but there's also, the reality is we really don't want to document everything if we're doing a bad job of it. So, it's really, really important to document certain things, important factual events, but we don't need to bog down our personnel files with a lot of unimportant records of events. So again, important factual events, good to keep. But generally why we want to document is, for me, I'm always, on my side of the equation, I am always thinking that every time I put something into a personnel file, every time I write a disciplinary note that eventually is going to go in the personnel file, every time I do a performance evaluation, I am always thinking, would I want this to be Exhibit 1 in a lawsuit? Now that's my life, and that might not be what you think, but I think that's very protective. The way I think of it is very protective. So and it makes me look over things like, okay, would I really want, this to be reviewed by a jury, a judge, and gone over in a deposition or on trial with a fine-tooth comb? Is that really what I would want to occur? And so that's kind of helpful, makes me step back and think, all right, maybe I should reword this, revise this, and not to make it inaccurate in any way, but to really make sure that these important documents, especially with regard to performance and employees' performance, that these important documents are succinct, they're accurate, and that they're then obviously kept. So, these are a litany of reasons why we might want to document, again, thinking of that, hey, would you want this to be Exhibit number 1 in a lawsuit? Your memory may not serve you well. That's just how life goes. People don't all have photographic memories. Wish it were not the case. I wish we all did, but we all don't. And people forget things from day to day, and lawsuits could happen 2-3 years after an event, if not even longer. But normally they're done within 3 years. That's a long time to remember something with specificity. And you're, in a trial type of situation, a lawsuit, you are called upon to remember things with specificity. And if you can't, that's a potential problem. And it might make you feel bad too. So we want to document things. We want to document important events so that we remember later. It's also easier for me on the lawyer side. It's easier for me to understand a situation, that's not through the lens of looking back upon it 6 months or a year or 2 years later, and look at it from a contemporaneous document, because a contemporaneous document is going to reflect. Normally, it's going to reflect the reality of the situation and the accuracy of the situation better than a document that's created after the fact, or a memory that's just orally given after the fact. And for that reason, judges and juries find those contemporaneous documents to be more credible. It just makes sense, right? You're going to believe, I mean, if you just think about it, you're going to believe what somebody wrote more often than not, that you're going to believe their memory at trial, which seems entirely self-serving, if they were to, say that their memory is this, that, and the other from 2 years ago. You're going to just, as a human, I think, take that memory into consideration less than the contemporaneous written statement of what actually occurred. So oral history is not, well grounded, certainly not compared to written contemporaneous history. And for those reasons, with regard to employment and HR, we definitely want to make sure that we are capturing those events, and that we are capturing so that we can put this together, and then eventually make arguments that, hey, we didn't engage in this bad practice. So when should you document? Again, important factual events, Whenever the event may affect, not that it does affect, but may affect the terms or conditions of employment. So, anything that could hit upon one of your code of conduct violations, like an attendance policy or a demotion, something like that. Anything that could impact a term or condition of employment, it should be documented. If you have even oral conversations, and I know I'm preaching to the choir, I know, with HR people, but supervisors, when they are orally counseling somebody because the person was late or the person's not doing a good job, whatever it is, but when they're orally counseling somebody, that needs to be put down into writing. That's best practice, right? So we need to get that down into writing so that there is a paper trail. So because is the supervisor really going to remember a year or 2 years later that they talked to the person about their absenteeism and told them that's the last straw, and then a year later the person gets fired over it, and then a year after that there's a lawsuit. I mean, we want to have documentation. You don't have to give written warnings to employees on all things. You can definitely talk to them. You can, that's fine. Supervisors can talk to them. But the best thing to do is for the supervisor to talk to them and then to create a paper trail of it. Because the key is we've got two types of, so when I think about discipline, I think of two types, right? We've got misconduct and we've got performance. And we want to create a document trail on both, showing that the person has been apprised of how they've been failing. So with regard to misconduct, we create a paper trail by doing the employee handbook, right? We put a code of conduct in the employee handbook. We say the do's and the don'ts, and this is what the company's about, but also this is what gets you fired. This is what gets you in trouble, right? So misconduct type things, code of conduct, attendance policies. Those are all things that we put out there that an employee is expected to follow. That doesn't have anything to do necessarily with performance, indirectly, but not directly with performance. And then so we want to document it, and we document notice by doing the employee handbook. And then on the performance side, the performance is where we need a ton of documentation, right? I mean, that's where it's like document, because we want to document that we have been conveying our expectations to the employee, and that we've been conveying to the employee that continued poor performance behavior related to performance is going to get them fired, that there are going to be consequences, and these consequences will affect the terms and conditions of their employment. So even if it's oral, we want to have a written paper trail of this so that we can confirm that, yes, this employee knows or knew that continued performance along these lines was not meeting expectations. That's why eventually, 6 months later, 9 months later, whatever it is, they got fired. So this is all leading up to getting fired. And if you think about it, like if I'm on a jury, or if I'm on a jury and I'm hearing that this employer, yes, they've got documents showing, yes, I counseled them, and then we gave them a last chance agreement, and then eventually fired. Well, that sounds like the person was given a chance. And when people are given, a chance, I think, and it sounds like you've got good paper trail of that, absent, really, really bad stuff that could have occurred. But if you have just a real neutral he said, she said type of situation, and you've shown that you've been telling the person along the way that they're not doing a good job, and that their continued performance along these lines could get them fired, well, it sounds like a process, and it is a process, and people like to feel like they're given a chance. And so if I'm on a jury and I hear that, I think, well, this person knew. I mean, it's not the company's fault that they continue to be a bad performer. So there you go. Good outcome, hopefully, for the company. And so it's so critical that we document anything that can affect the terms or conditions of employment. Anything that, when management's taken action, so if you've done a harassment investigation or a bullying investigation, whatever it is, any sort of investigation into conduct or a practice at the business, then you definitely want to document that as well. And because that shows follow through. It shows that you're not going to put, sweep things under the rug. It shows that you're a diligent employer who takes the laws seriously, who truly wants to make the workplace fair and safe for employees, and that you did an investigation, you looked into it. People might disagree with the outcome of the investigation, that's fine, but the key is that we want to show a process. We want to show neutrality as much as possible, and we want to show that we care and that we're trying to comply. That's why we, again, documentation is way better than it's going to create so much more of a defense for you and reasonableness argument if you are ever brought into a lawsuit. I already made that point on the third bullet point. Okay, so I don't really care what form you use. Ideally, this is what would be on the form. Whatever form. You can create a form, you can get one off the internet. When we're talking about discipline, doesn't matter. It needs to have so many times I see that the supervisor who's doing the written warning, sending something to HR, won't put their name on it. They don't sign it. An email's fine, then you can always kind of figure out who it is. But a lot of times it'll be just something in writing, just a quick little page like, I told so-and-so, to knock it off. And there's no date. It's got to have a date on it. So if there's a disciplinary notice of any or document of any kind, it has to have a date on it. It has to have the name of the person who delivered the warning, who delivered the notification to the employee about performance or misconduct, whatever it is. That person, normally it's a supervisor or a manager, that person's name needs to be on there. It doesn't necessarily have to be signed, but the most important thing are the dates and the name, so that it shows that, so we can recreate the paper trail and recreate the event if necessary. Yeah, just the facts. I always say that, especially when counseling on harassment or bullying investigations in the workplace, we just want to know the who, what, where, when, and why. We don't want editorial comments. Nothing about personal lives in there unless it's relevant to this situation. We just want to be like, some sort of police officer that's really good at their job, I guess, and does a really good job in just getting the exact facts, ma'am, right? So that's all we want. That's all we want when we're documenting, particularly when we're documenting on employee conduct or performance. On to the hiring process. Let me check to see if there were any questions. Nope. Okay. The hiring process is in various phases, and so I'm going to run through those quickly because there's documentation along the way. I suspect so much of the documentation that you have on employees, probably most of it, I suspect, depending on how long the employee's been working for you, is going to be from this like first week or so, like the hiring process and the onboarding process. Obviously, there's going to be documents after that, FMLA and medical leaves and all that sort of thing. But again, not in the personnel file, but you're going to have all that documentation. But just going through the pre-hiring gathering information process, it goes in phases, right? So when I think of the hiring process, I think of we do a pre-hiring process from an HR perspective, right? So we need to figure out what the job description is. We often, best practice, we talk to the supervisor, we talk to the manager, and we get an understanding of what that job is. And that's an important document. We don't think about job descriptions, but job descriptions are really, really important. They set the tone for what the company's looking for. They could say something about the company's culture, the way the job description is worded. I've seen some crazy job descriptions where, they're really trying to go after millennials. You can tell they're going after millennials with the way that the verbiage in the job description, it's really loose, it's friendly, versus more common job descriptions, which sound like a computer, spit them out, and they're stale, they're curmudgeon-y, if they can be curmudgeon-y. They sound like something a lawyer would write, so something I'd probably write, I guess. But everybody can have, but a job description is really the first chance that you have to present your company, your culture, what you're looking for to that prospective employee at that time. So that can be really, really important. So that's a really, really good document, and it's critical that the job description sets out the essential functions of the job, and that you as HR, before you post that job description, that you fully understand what that job entails by talking to the supervisor and bringing them into this conversation. And then once you do, once you determine, criteria and essential functions of the job, you're going to collect the resumes, right? And you're going to look at the resumes and make good determinations on who's qualified based on, again, the essential functions of the job and what you're looking for. We want to weed out based on objective criteria, and some employers will create documents that will say, and this is a fine practice, if you are posting for, let's just call it an electrical engineer job, and you understand what the essential functions are, you could talk to the supervisor and rank what the important, like what you're really looking for in an applicant, and you would rank them, and having that document where you're showing objectivity in the ranking and like what you're really looking for, that could be a fantastic, again, assuming it's objective and not discriminatory. If your number one thing is they're not Muslim, that's not going to be, it's not a good idea, right? So as long as it's objective and non-discriminatory, and you're putting that together, you've got like 3 to 5 things, and that's what HR is looking for when they're doing the initial weed out. Well, that could be a fantastic document for showing to the EEOC or some state Department of Human Rights that no, this is why so and so wasn't selected. These were my marching orders. Yeah, they might have been qualified, but this is what I was really, these were the 3 to 5 things that I was really looking for. And as you can see, these are neutral, non-discriminatory. And this person who applied and didn't get selected, that person measured poorly on what we're ranking here, on what we're really looking for in an applicant versus somebody else. And so that document could be really, really great in a lawsuit. But again, I said before, document, but if that document says, number one thing, don't hire any Muslims, well, that's a terrible thing to document. It's a slam dunk loser lawsuit for you, and so you definitely don't want to document that. But anyway, that could be a handy thing as well. And you might do something similar on an interview, like when you're going in and you've got essentially speaking points where you're really trying to get certain information from candidates. On the measured up against those speaking points. Here's just a general interview questions, areas to avoid. I think this is kind of HR 101, things not to ask, and I wouldn't go after these things directly or indirectly. It's just, if the employee brings it up or the prospective employee brings it up at an interview, that's something entirely different. But if we don't want to be interviewing somebody and then ask if they've got any kids, right? What daycare do you use? Well, I don't have any kids. Oh, what's your husband do? Okay, it sounds friendly and everything, but these are things that every HR person's told to avoid. I just wanted to put them down on a list. It actually, especially for newer HR people, if you're doing training, it could be the sort of thing that you give a newer person some, a list like this and say, just, please avoid this. So this, maybe this list right here could be used for you for a training tool. Conditional offer of employment is a nice document that we have. It's essentially an offer letter. So when the offer letter goes out to employees, and I don't know how many of you do offer letters, I suggest that at least certainly for professional jobs, that offer letters are created. They're a nice document that goes in the personnel file, and it'll list like what the actual job was. Then you can measure it up. You can match that up against the job description, so you can understand exactly what the job entails if there is ever any question of what job the person does. But it's just nice to have that documentation showing what job was offered and then what the wage was offered and then whether or not the person would be eligible for benefits, that sort of thing. It's a very basic document that's like a paragraph, maybe 2 paragraphs long at the most, but it's really nice to do. That offer letter is always conditioned. So every offer of employment, we don't talk about it this way, but it really is a conditional offer of employment. So you'll give the offer letter and say, yeah, start to work, and you might even put in there that this offer is conditioned upon satisfactorily completing the I-9. You should bring your documents. Here's a copy of the documents that are available for the I-9. for list A, B, and C, bring in either an A document or a combination B and C document. I mean, that's the type of thing you could definitely put into an offer letter. If you have other pre-employment conditions that need to be satisfied, like drug tests or criminal background tests, or the signing of a restrictive covenant agreement, like a non-compete, non-solicitation, or a confidentiality agreement, then you definitely want to put that into this job offer, because yeah, it's an offer, but it's also a conditional offer. And so job offer, good document to have, and it might reference, these other documents like testing, background checks, that sort of thing in the conditional offer of employment. As part of the hiring process, you're going to verify that all of the conditions have been met, right? So you might even have a little checklist. You've got your criteria, maybe 3 to 5 that you've identified after talking to the supervisor. Also, you've got the essential functions of the job, and you're going to go through the candidates and the ones that you interviewed, and you're going to determine whether or not the criteria has been met. You're going to review the drug testing or background check. You're going to review all these other criteria, like the I-9, make sure that's all been done, and then boom, you've got the candidate, and they start working for you, and they might actually start working for you, and then you do the I-9, for example. But most of the others, like background checks and drug testing, those are all done before the first day of employment. And again, you could definitely create a checklist that just kind of takes you through this process, kind of like an audit, that just guides you through this process. Review resume. Did I go over the resume with the supervisor? Check. Do I have a list of the key things that we're looking for from a candidate? Check. All these little things. You could create your own list that you use, and that list doesn't have to go into a personnel file, but it certainly could go into a personnel file, and it would be nice, and you could take it through the whole process, ending with orientation and and benefit information and all that. You just do a little checklist of all these things. You could put it in the employee personnel file if you wanted to, and it would show that you did all these things. You don't have to put in the employee personnel file, but it's something you could put in there, though probably makes more sense to keep it out. Either way, I'm pretty neutral on that one. Somebody asked a question. Okay. This is a good question, so I'm going to read it. And then we're going to talk about mandatory provisions in a handbook, since a handbook is probably the most important document that we have in HR. Okay, what if the reason for leaving multiple jobs is written on the application as family reasons, no child care, taking care of sick parent, etc.? Can you ask? And I would say it sets you up a little bit on this question. It is a little bit risky to ask. If I were to say union affiliated, member of SEIU, 101, you're not going to want to ask about that. In this situation, I don't know if I would ask. I would say that there's some risk. That being said, the person has opened themselves up for it. So I certainly think there's less risk if you were to go down this rabbit hole because they've opened it up. But I would only ask if you really need to know for your business going forwards. Like I guess the way I would say is I probably wouldn't ask about the past with regard to family reasons, having no child care, taking care of sick parents. I probably wouldn't ask on those things, but I would lay out what the expectations are for this job. This is a 40-hour job. I'm just guessing here, right? This is a 40-hour-a-week job. This is the type of job where you need to be on time. We have an attendance policy, but this is not a laid-back job where you can just like roll in 5-10 minutes late. Like we need you here. Do you see any issues with that? And if then they start bringing up excuses, I think then you kind of have your answer. But I think I would probably avoid, even if on an application they talk about the reasons for losing jobs in the past as potentially these just kind of wayward questions that we want to ideally avoid. I think I would address it that way. It's similar to how we talk about it with disabilities, right? Like somebody walks into an interview and their right arm's in a sling, and the job entails pushing carts, right? I mean, we're not going to ask about the arm in the sling necessarily, but we're going to talk about the job. We're going to talk about like, hey, I notice here that you've got potential impairment. This job requires that you push carts, 50-pound carts. That's essential to this job. Are you going to be able to do that? Is there anything we can accommodate? So you have that conversation. So I hope that's helpful. And then finishing up this question, and along the same lines, if they mark incarceration in Virginia, you can't. The person asking the question can't ask about felonies, but I've had applicants put it as a reason for leaving previous jobs. Minnesota is the same. A lot of states with the ban the box. I think we've got, off the top of my head, I think 23 states do ban the box. So 23 states are along Virginia's lines where you can't ask pre-employment or at least pre-interview questions about criminal history. So if somebody puts it on there, it's out there. I mean, that's information that you have. I don't think you need to ask about it, but could you take it into consideration if that's relevant for the job? If somebody, having been incarcerated is relevant for the job, I think so. I don't know at what point you can ask about past criminal histories in Virginia. Most states with ban the box, Minnesota included, for example, and I believe Illinois as well, just off the top of my head, and I think most ban the box states, you can talk about criminal history at the interview, but you just can't ask for it on the application. That's just too soon. But in Minnesota, once you offer an interview, you can do a background check into criminal history. You certainly can talk about it during the interview. So we just might want to check Virginia law to see, because if you're in an interview, you can probably ask for it. But otherwise, yeah, you don't have to ignore it if it's on the job application. But again, whether or not that's critical for the job, the background, the criminal history, you'll have to make that determination. If it's immaterial, then I wouldn't just nix somebody based on in their incarceration history. Mandatory handbook provisions, so things that we definitely want to have in employee handbooks. And do you have to have an employee handbook? No. I mean, I don't know of any law that requires an employee handbook. There could be some out there. I'm not familiar with them. But if you do have an employee handbook, here's what you want. You definitely want to have contract disclaimers, the at-will employment language, right? Everybody here is at will. So at-will employment, there's no contract for employment. This handbook is not a contract for employment. Wage payment provisions, we want to talk about, timing, when wages are going to be paid. We want to have a complaint reporting procedure. That's for harassment complaints and complaints of discrimination primarily. It offers us, if we have a detailed complaint reporting procedure, especially on harassment, it allows your lawyers to argue an affirmative defense if the person fails to go through that complaint procedure and then just quits and sues you for harassment. So we definitely want to have that complaint procedure in place, because if they don't use that complaint procedure, you can argue affirmatively that they're not entitled to any sort of damages or recourse because they failed to comply with it. So probably the most important thing to have in your employee handbook is that anti-discrimination, anti-harassment complaint procedure mechanism. You could have some stuff on leaves, definitely like vacation and sort of those sorts of benefits. Definitely want to have that in there. If you're doing drug and alcohol testing, you could either have that in the handbook or you could have that separated from the handbook. You probably don't necessarily have to have a drug and alcohol testing at your business unless it's required, pursuant to a contract or something. But if you do, it could be in the handbook, and then definitely an acknowledgement of receipt, and then a code of conduct. So disciplinary policies, if you're going to have step discipline, you want to have that laid out in there. honestly, I don't like to lay out step disciplinary processes and procedures in a handbook. What I like to do is just reference to them that what the code of conduct is, what the expectations are, and then have the supervisors trained up on what the expected protocol is when they're going to discipline employees. And again, talking differently about misconduct, discipline versus performance-related discipline. And then definitely an acknowledgement of receipt form. And the key there is the only reason you want that is just to show that the employee received it. Could be electronic. It could be in writing. Doesn't matter. And then that definitely will go. That signature, at least, on that handbook will definitely go into the into the personnel file. We're going to get into some key documents here with the remainder of our time. One key document, so the Fair Labor Standards Act, the federal wage hour law, right? These are the documents. So you have to, for non-exempt employees, this litany of bullet points here, this is what you need to always maintain for those employees. The information that you have to do for non-exempt employees. Now, exempt employees, not really, not so much. You don't have to worry about that. But for non-exempt employees, you need to maintain these records for 3 years with all of this information. And a lot of this is just kind of detailed on your pay stubs, so it looks really onerous, but it's, you know, not a big deal. But most of you, if you're using a payroll system, this is all going to be part of your time and attendance, right? But I wanted to put out the list just to make sure, like, hey, if you're going to do an audit, because, you know, if you're not using a major payroll system where you're, you know, doing it kind of on your own, not recommended, but if you are kind of doing it on your own, or you're just not confident, it's good to go through this to make sure that all of these things are being maintained and calculated on a payroll, on a pay period basis. So, and if they're not, you will have to change that. Okay, I say PHI, protected health information, but really we're talking about medical information. Let me say what the definition of PHI is. So it's all individually identifiable health information transmitted or maintained by a covered entity. Most employers are not covered entities. Again, we talk about HIPAA. We have HIPAA compliance issues in other aspects, and we talk about PHI, but for the most part, the documents that we deal with are really not PHI related unless we, you know, our health plan, so or some sort of health, you know, hospital or association or something like that. But most employers not in that boat, so we don't really worry too much about PHI. That said, there are exceptions, and some states may, like California, may extend PHI to employers, and so we then would have to look at PHI, the medical information that we might get when we're asking about reasonable accommodation, you know, medical information we get from a doctor when we're going through the reasonable accommodation process. That might be covered under California law, so we have to treat it like PHI. FMLA, medical certification information, treated like PHI. Either way, the ADA and the FMLA, which is probably covering most of you on this phone, on this call, the ADA and the FMLA are going to require that we have restricted access for these medical records, and that we have separation from other employee documents. And so it's not so much HIPAA, which is driving why we have documents, medical related documents, separated from personnel files, so that supervisors and all those, you know, good people who could mess them up and you know, get us into trouble with lawsuits. It's really the ADA and the FMLA. So examples of things that fall under this, you can see the examples, definitely the medical certifications and medical histories, anything that has this medical, you know, I think of it like PHI, but anything that's medically related that could get to an employee's medical history or condition. And we just don't want supervisors and managers to know about that, because we don't want that to influence them in their decision-making process, right? I mean, an employee who's been a good employee for a long, long time, suddenly the supervisor sees or gets some sort of wind, or sees the document regarding medical history, and then suddenly, you know, the supervisor is being pretty tough on them and taking them down a disciplinary path, that just leads, the supervisor starts pressing HR on helping them to do this. It's like, well, no, this knowledge, you shouldn't have had access to this knowledge. This knowledge seems to be influencing your decision making, your management of this employee. Now, there could be need to know the supervisor. Certainly, if you're going through the accommodation process, supervisor might not necessarily need to see the medical documents, but definitely having a conversation with the supervisor about, hey, this employee is going to need some intermittent leave. They're going to be on FMLA, and this is the situation. They might have seizures. They might have to disappear for half an hour while they're seizing, things like that. First responders as well, feel free to tell a first responder that, hey, this person's got such and such, disease or condition or whatever it is. And you can definitely share in that sort of medical emergency situation. Just a tip for you at the bottom, when we go through the ADA, the reasonable accommodation process, you can definitely, it is within your control, your power, to ask for medical documentation to substantiate that there is a disability, and then 2, that they need an accommodation. So this is information you can't ask for like a lot of specificity with that information. You just ask generally. A lot of employers, ask really, really specific details to when they're going through this reasonable accommodation process, and that's not really what the EOC wants you to do. What the EOC wants you to do is just ask generally for this information, so that you can make an accommodation determination. Tips, you can see, keep these medical documents under lock and key, maintain them separately. We've talked about most of this. Restrict access. I don't know if you as HR just have to like start working out, pump and iron, whatever it is, but definitely, keep the supervisors and managers at bay. We definitely want to keep that information. Also, there's also some privacy rights that employees might have if their medical information, say privacy laws that would protect their medical information. There are 3 key FMLA forms that we deal with, and this is an overview of each of them. And I was going to show you, I saved these handouts, but I don't think I have time to show you what each of them is now. But the first one, let me take you quickly through this. For those of you who are not as comfortable with FMLA, when an employee comes to you, or if you have reasonable belief to believe that the person who's eligible for FMLA, because they've been there working, you're a covered employer, and they've been working for you for at least a year and have worked at least 1,250 hours in the last 12 months, and then they need some time off for some sort of medical condition or birth or adoption or whatever it is, you automatically want to kick them out. Once you've got that knowledge, you automatically want to kick them out a notification of rights and responsibilities. It's a WH 381. And I can send any of these forms to you if you don't have them already. But you got to kick that out to them. And part of that is, hey, I need, in order to know if you have FMLA, if you're eligible, if your absence here is going to be covered by FMLA, and we only care about this with absences, right? This is to protect the person's absence that they're having. And so if you need medical information, you're going to click the box on the form that says that they need to provide a medical certification within 15 days. And then the employee has 15, or the employee, they're going to give it to their doctor, but the employee is responsible for getting this medical certification. I think that's actually the next page. This medical certification to you. They're responsible for getting the medical certification to you completely filled out so that you can make a determination on whether or not they're eligible for FMLA. And then once you have that, information, then you're going to fill out the designation notice designating that they have FMLA or not FMLA. I'm going to skip over a couple things since we're running out of time here. Employee access laws. Here's a brief review for those of you in a lot of these states. Noticeably, New York and Texas don't have laws entitling employees to access their personnel file, but a lot of states do, including Massachusetts, Minnesota, Illinois, Wisconsin, California. Very common that a state will have access rights for employees, guaranteeing that they have a right to see, sometimes copy, their employee personnel file. Those are tips, and then general, let me go here. Record retention, all of you have this PowerPoint, so you can kind of see what this is, but with regard to record retention, there are certain statutory requirements where you have to keep these records. And so we don't want to shred these records until, you know, we absolutely can. And then here's a litany of some of the records that you absolutely have to keep. Now here is what the law requires, right? So like FMLA, 3 years post-termination. Here are what a lot of HR people best practices do. These are general policies, so a lot of employers, you might be one of them, will just have a record retention set for 7 years after termination for personnel files. For medical benefits that are in a separate file, the separate file, they'll do 6 years. I-9 form, you know, this is very common for companies, rather than looking at each individual record and be like, okay, I can get rid of the application today and the I-9 and 14 months. I mean, you can do that, and that's easy to do if you've got electronic systems in place. But if you just want to have general policies on this, this is what a lot of companies do. 7 years, 6 years. The I-9 form, you're definitely going to cover the I-9 form if you go with the 7 years, but you know, you can always do just a year after termination. You'll be fine in most situations, or 3 years after termination for sure. You'll be definitely fine. Hiring records, 2 years. This is definitely going to cover you. It's going to be longer than you definitely need, but it also makes it potentially easier on you when you're setting up a document destruction system for your policies. Okay, I missed the I-9. I'm happy to talk to people about I-9s anytime you want. I did just do a webinar on it two months ago. So certainly if you're on the HR Hotline program, you can always rewatch that webinar as well, which is much more detailed. Next month, I think it's the day before, my secretary knows what day it is, but anyway, it's like annual medical, it's like annual drug marijuana day. There's probably a better name for it. And I think that's on April 21st. Anyway, so we're going to, on April 20th, we're going to celebrate it, I guess, in our own way, our own HR way. We're going to celebrate whatever April, the drug day is. We're going to celebrate it the day before with a webinar on drug testing and medical marijuana. There. I appreciate everybody's attendance. Sorry that I went a couple minutes long. If you have any questions, definitely feel free to reach out to me at any time, and your certificates will be emailed if you noted that you need HRCI or SHRM credits. Thank you very much.